237. And this was the one that we had discussed earlier last Thursday afternoon. We had laid it on the table subject to call, so I'm calling it off the table. It's the sentence suspension prohibiting for crimes involving the exploitation of children. And if our friends from the Attorney General's office is here, hopefully, yeah. Hey, Gregory, if you can just give us a brief refresher for those of us that may have forgotten about it over the weekend, what this bill purports to do, and then we'll recognize Senator Simmons. And I think he had some questions about it. So, Gregory, talk to us about it. Great. Are there any questions about the bill? Senator Simmons, you're recognized.
Yep. Thank you, Mr. Chairman. Gregory, you provided me a printout from the crimes that you all have prosecuted and a list of sentences around the state. And I guess my question is, when you say several judges have been doing probation, based off the list that you provided me, about 80%, if not higher, of the judges gave people jail time. And I guess my concern about fooling with Title 97 is, for instance, one of the sentences was from Judge Harrell. And Judge Harrell sentenced someone in 2013 to a 10-year sentence, 3 years to serve, and he suspended 7. I guess my question, if what you are proposing becomes law, that sentence that Judge Harrell gave, would it have been just a 10-year mandatory sentence?
Sure, go for it.
Okay, I see. So what he did was he gave a 10-year sentence, which was between the 5-year and the 40-year that is outlined in 97.533. But what your goal is to make sure that 5 years is always mandatory. A minimum of 5 years is mandatory. And so I want to work with you. I think the only concern I'm having is the best place to do that is go to the crimes title, which is 97, and where we have 5 years to 40 years, add just one line that says the 5-year minimum shall not be reduced or suspended, like we've done in many other criminal statutes. I'm afraid that when you actually fool with 47, which is parole and probation title, that what's going to happen is some judges are going to basically feel like if all the part of the entire sentence is a mandatory sentence. And I think the application of that across the state will not be achieving what you are trying to achieve. So I think one judge may be within that 5 to 40 years and give someone 20 years, and it's a 20-year mandatory sentence. Another judge may give someone 30 years, it's a 30-year mandatory sentence. In the case of Judge Harrell, if we go back to 2013, what he did, by giving that 10-year, I believe if you actually change the language in Title 47, that 10-year would have been a 10-year mandatory sentence. And I agree with the goal you're trying to achieve, and I support that goal.
Senator Simmons, would you like to make that amendment?
That'll be my amendment, Mr. Chairman.
All right, you've heard the amendment. Any questions of the amendment? If not, all in favor say aye. Aye. Any opposed, nay? The ayes have it. All right. Any other questions? If not, for motion,
Title sufficient do pass, Mr. Chairman.
committee sub.
Committee sub.
All in favor of the messages? The motion say aye. Any opposed, nay? The ayes have it. Thank y'all so much. And thank you, Senator Simmons. All right, Senate Bill 2244, we're going to recognize our esteemed committee counsel, Mr. Ethan Samsel, to explain this particular bill.
Thank you, Mr. Chairman. 2244 is the Miller bill. It's conforming our sentencing statutes to the Miller case. That's about 15 years old now. I'm not going to belabor it. We passed this out of the Senate last year. In Miller, the United States Supreme Court considered the constitutionality of sentencing juveniles convicted for homicide, and they found that an imposition of life without the possibility of parole was a violation of the cruel and unusual punishment, the Eighth Amendment. The line of cases has been developed by the Supreme Court and our Supreme Court as well, our state Supreme Court. So right now, our state Supreme Court has to have a special disposition line that says not considering the statutes that we have. So that's what this bill is trying to do, is bring it back in line with what the Supreme Court is currently doing. Turning to the bill, see the operative language throughout. That first section is 97.321, and then the main, and that sets out the penalties for the juvenile. And then line 61 is actually reaching back to 2005. It's a U.S. Supreme Court case that said death cannot be imposed on a juvenile. And then line 63 to 65 is more Miller language there. And it's actually bringing it all the way up to Jones v. Mississippi, which was the most recent U.S. Supreme Court case back in the spring of 2021. And they found that you didn't have to you didn't have to consider each Miller factor individually. So this law should be in accordance with that. That's the committee sub there.
All right. Heard the explanation. Any questions? If not, yes, Senator Simmons.
Thank you, Mr. Chairman. Is it the intent in this bill that a judge can sentence someone to life without a jury?
Good question. Let's see.
Yeah, I believe that's correct. After hearing all the evidence, the jury or the judge sitting without a jury, they would have a Miller hearing, a special sentencing hearing. So the jury would find as far as guilt, but the judge would sentence. So this wouldn't waive their right to a jury trial as far as the actual guilt to the crime. The judge would have a special Miller sentencing.
But that special Miller sentencing will be without a jury.
That's correct. Line 186 and 187, and also lines 85 and 86. I'm sorry, those are out of order.
And for second degree murder, a jury will be involved in sentences for second degree murder based off the bill. Is that correct?
I couldn't hear that. Did you say
I
that
don't know
again,
if it would be
Senator?
in all cases of second degree murder. I'd have to look at that, but yes, that's correct. But this is just in accordance with what the Mississippi Supreme Court has done in their case law interpreting Miller and Montgomery, several different U.S. Supreme Court cases. So it's bringing our statutes in line with the current precedent that's set by the Supreme Court.
I guess my concern, Mr. Chairman, is that don't we still want, after the guilt phase, for a jury to be involved in determining life for minors? Not adults. It's minors.
Any other questions? All right. Promotion?
I have a question.
Okay, Senator Wiggins.
The language, I guess this is for Ethan, the language that you've done, this is set out by the dictates of the Supreme Court and Mississippi Supreme Court. So we're not, I guess in other words, we're not doing anything that is, untoward or out of the ordinary.
What was left with the way the statutes were before this language is that there's an ambiguity as to whether there is a jury or not, and the Supreme Court has decided that there isn't. It's not constitutionally required.
That a jury is not constitutionally required. Okay, and that ambiguity, that's what we've been trying to fix with the Miller language here, and actually this Miller language of similar version, or actually this have come before in the past couple years, right? We've tried to get that because at this time, the judges, the prosecutors, even the defense attorneys are all in limbo about what's going on. Is that right?
Yeah, that's correct. I mean, it's settled law in the Mississippi Supreme Court, but the disposition line says notwithstanding the statutes, basically the way the law is written.
So there's no constitutional requirement as set forth by the Supreme Courts, U.S. and state, that there has to be a jury.
Right.
Thank you.
All right. Any other questions? Senator Simmons?
I just wanted to express my concern again, Mr. Chairman. It's just, I understand that ambiguity is out there, and it may not be unconstitutional based upon what our Supreme Court has decided, but also based off Miller, the reason why we are here is because we want to try to make sure it's clear in the statutes. And so if a jury decides that a minor is guilty, then I just think it'll be better policy in the state of Mississippi for that same jury to determine whether or not that minor gets life, as opposed to just one person.
So you're going to speak against the bill?
I think I just did,
Okay.
Mr. Chairman.
I think you just did. All right.
Thank you.
You're welcome. All right. Any other questions? If not, for a motion,
House sufficient to pass.
House sufficient to pass committee sub
Any substitute.
is the motion. All in favor say aye.
Aye.
Any opposed, nay.
Hey.
I believe the ayes have it. The ayes have it. Okay. Senate Bill 2246. Again, we'll go back to our friends at the Attorney General's office. This was dealing with arrest warrants issuance for sex offenses against children upon oral testimony. Which of y'all want to tackle that one? So the current method for those of us who don't practice any criminal law to get one of these is to drive across the state from Jackson to wherever the judge is in that particular district, present the information to him or her, and get a arrest warrant or a search warrant, as it were, signed in person. Is that the way that goes? Or her approval of it. Yeah. Okay, questions by committee members? Any questions? Not motion. House sufficient to pass the motion. All in favor say aye. Aye. Any opposed, nay? The ayes have it. Thank you again, Mr. Olson. All right, number 4, Senate Bill 2545. We're going to recognize Senator Thompson to explain his bill.
Thank you, Mr. Chairman. Senate Bill 2545 is an effort to address counterfeiting converters theft in our state. I reached out to my sheriff initially over the summer. It is a pretty serious problem down around my neighborhood in my neck of the woods. And after introducing the bill, I've heard from several different members. It's a problem all throughout the state. So this bill is an effort to tighten up the resale of the catalytic converters and tighten up that market and closely mirrors our current scrapping law. Section 1 of the bill will create Section 971771.3 and make it unlawful for anyone to sell, purchase a detached catalytic converter, which mechanic that's defined to mean a catalytic converter has been removed from the vehicle unless certain requirements are met. Subpart B starts laying out the requirements that the person who's buying the catalytic converter, or I'm sorry, the individual seller, his obligations, things that you have to provide. The bill provides that this individual seller has to provide the name of the person who removed the converter, the name of the person for whom the removal was completed, make and model of the vehicle for which the catalytic converter was removed, the VIN number, any other part number identifying the catalytic converter, and a copy of the driver's license or ID card of the individual who's selling the catalytic converter. We also have to provide a copy of the certificate of title registration for the vehicle that the catalytic converter. That's designed with the intent there is anybody who's legitimately removing a catalytic converter from a scrap vehicle or something like that, that person's still free to transit or negotiate the sale of that converter with someone who maybe stole a catalytic converter, not like the animal. Part E that starts on line 57 sets forth the buyer's obligations. The scrap metal dealer who's buying the catalytic converter. That he has to verify the documentation, the person who's selling it, and retain a record of the verification, the information that he receives. And then section, we'll start on line 79, sets forth the violation. The person who's going to be violating that section is guilty of a misdemeanor or a felony for subsequent violations. We're not satisfying this purchase and sale requirements. Section 2 that starts on line 88 of the bill is current law or revisions to current law. That's section 971771. Revisions are on line 117, 124. And that is in the definition of metal property. It revises the definition of metal property to include detached catalytic converter. And also in there on lines 408 and 411. That addition there provides that scrap metal sale section shall apply to the requirements of purchase, possession, and sale of detached catalytic converters in the newly created section 97-1771-3. Section 3 of the bill, it starts on line 412, adds detached catalytic converters to the existing scrap metal dealer laws. We already have existing laws for certain metals that apply to our scrap metal dealers. Those laws apply to our scrap metal dealers. This revises that section to include attached catalytic converters to those scrap metals. That's a general explanation of the bill. I'd be happy to answer any questions.
So I'm assuming the scrap metal dealers have been involved in the preparing of this particular
I wouldn't say the scrap
bill.
metal dealers have been involved. It's more law enforcement.
Gotcha. All right, questions. Senator Simmons.
Thank you, Mr. Chairman. I guess my question to Senator Thompson.
Yes.
You want to yield, Senator?
It's up to him if he wants to answer what I guess.
You know you're my friend. Well, this is not a problem in the Delta, so I just want to issue that disclaimer. Are there any other parts of cars that we are seeing is also a problem other than catalytic converters?
Well, there may be
Okay.
other issues. The issue with the catalytic converters, it's got created into a market here in Mississippi. Alabama recently enacted this very similar legislation. For example, on the coast, and I-10, understand in other areas of the state that are close to the Alabama line, those guys are coming over, stealing in Alabama, coming over here because it's easier to sell. And when they're over here, the neighborhood and pick up.
And so under our current grand larceny statutes, would this not apply if somebody steals something and the value of which is more than $1,000?
Well, I'm not a criminal lawyer. They purchase these things around $300, $250, $300 is what they purchase them for. The scrap metal dealer purchases them for. When he resells them, they're worth significantly more. The issue has been with enforcement of my sheriffs that told me the story again. The neighborhood of Long Beach, they get like 22 vehicles. We post up on his deputies post up on the dealer in Gulfport there that morning. Known criminal and his buddy show up with 22 catalytic converters. Like, they were able to seize them under being suspicious of stolen property. However, the guys were pretty sophisticated over. They go back to the shop, they recut. So you can't match the cut marks from the converters that are being sold to the converters that are being sold. The converters that were stolen to the converters that are being sold. So what this bill is an effort to tighten up on the purchasing end, on the scrap metal dealer end. Look, if you're going to buy a lot of scrap metal catalytic converters, there are certain things that you have to provide so that we can make sure that those catalytic converters are sold.
Senator Barnett.
I just want to, thank you, Mr. Chairman. I just wanted to speak to the bill.
Yeah.
And I appreciate that, Senator Thompson, for doing this, because if you are in the utility industries, what we have noticed that when all of these trucks are in the yard over the weekend, come in on Monday and nobody can move because all the catalytic converters have been removed from utility vehicles. And so, and it's a headache, especially when you are faced with tornadoes or hurricanes and that type of stuff, and you are needed somewhere else, even out of state, to assist, and you can't leave, you can't move because of the theft of all of the catalytic converters and things off of utility vehicles. So it is a problem, and I appreciate you working on this to make sure that we do something to tighten this up so that it's not only a convenience for the people in the utility industry, but for the customers who are dependent on these individuals to help in their outages. So thank you for that.
For the record, it's only a problem in Senator Thompson's part.
Senator Hickman, you recognize?
I just also want to say I do understand, and it is a slight problem, maybe not a bigger problem in my area. I've known a lot of these to come up missing, and people are afraid of that. But my question from the bill is: have we explored other ways? Do we have to have such an extensive list of things that a scrap metal dealer needs or has to retain? Like, have we thought of ways where we can say 2 or 3 of these things is sufficient? Because I mean, it's a long list of things they're going to have to collect in order to buy a catalytic converter, and they may just be getting one from somebody. I mean, it may be somebody's grandma's, old scrap car that they had in the yard that they may not even have, all of these titles for. I'm just thinking, have we narrow tailored this as far as we can to reach the purpose that we need to reach?
That's a great question. I'd like to point out first, scrap metal dealers are already a regulated industry. There's no providers metals that they deal in. They have to provide very simple information. For example, the copper metal thing. It's the same sort of idea. The idea that you can't stop someone from stealing it, but you can devalue stolen good by making it harder for that person to fix. So that's the idea here. For in your example, the one catalytic converter, very well called, that it should be fairly easy for him to provide all this information. The challenge would be for larger operations, let's say a scrapyard that's going to scrap a number of cars. That guy is going to have the titles. There'd be a lot of things, but he would be able to do that. He'd be equipped to do that. And also, for this tightening up the market like this, for the legitimate sellers of the catalytic converters, should actually increase the value that they would be able to receive. This is really an effort to try and tighten up the market, resale market for catalytic converters, not necessarily to punish the legitimate sellers.
Yeah, absolutely. I understand that. I just know, like, I've worked on like a title was one thing that caught me interested. I had a client. It took us kind of different story, but it took us a year and a half to get a title for various issues or another. And then, this was for an insurance claim or whatever that we needed it for. And so I know that's just sometimes difficult to come out. That was my only question. Thank you.
Thank you, Senator. Senator Sparks.
Thank you, Mr. Chairman. And Senator Thompson, the one thing I guess we're dealing with middlemen to a great degree here. We already have people who are reputable secondary metal recyclers. But what I'm hearing from my sheriffs is the guy who has the 22 catalytic converters is selling it to a middleman who's then showing up, and we're not able to prosecute the people who sometimes who are stealing them. We catch them in the act, but it's the middleman who's made all the money that would not meet this criteria, which would help us kind of stop this in its tracks. Is that part of the process?
That's the intent of the bill. I know we say this a lot, and I don't always like to hear it, but this is very similar to what Alabama did.
Sure. Well, when they stole the Cadillac converter off the church bus, it became personal. So that has happened all over our state. So
That's happened a lot.
thank you for your work on this bill.
And school buses. It's school bus yards. So that's the intent of the bill. It's not designed to try to punish the legitimate sellers or try and tighten the market.
Senator Turner Ford.
Thank you, Mr. Chairman. So this bill also requires some sort of registration with the Secretary of State's office?
Yes, ma'am. So in the sections 2 and 3, section 2 is our current scrap metal law. It defines aluminum materials, copper materials. That was the law that was enacted back when. And it adds the definition of metal property to include attached catalytic converters. And then in section 3 is the current scrap metal dealer laws. That attached to the catalytic converter to those current scrap metal.
I don't know anything about catalytic converters. Do they have identifying numbers per piece of equipment or per converter?
I've learned more about catalytic converters than I wanted to. Some do, but most do not. Is what I've learned.
type of list or registry we expect the Secretary of State to maintain if these individual pieces of equipment they're not specified or marked?
Oh, no, ma'am, I'm sorry, the dealers would be the ones that would maintain that information when they're buying it in the first use. The individual or the scrap metal dealer who's selling them, they would be the ones who would provide that information, the VIN number, the owner, who removed it. They would be the dealer would be the ones that would have that information.
And that's the information that the Secretary of State would have to maintain.
And then we have the dealer would maintain.
So what do we expect the Secretary of State to do?
The Secretary of State currently licenses and regulates the scrap metal field. This would just add and attach catalytic converters to that current scrap metal field. So, I'm sorry, chart 4, section 1 of the bill, on page, again on line 37, the individual seller obligations. And start there on line 37. That's the information. Name of the person who removed the catalytic converter, when the move was completed, make and model of the vehicle, the VIN, all that stuff. That is information that the seller has to provide to the scrap dealer. And the scrap dealer's responsibility is to maintain that information. Everything else is not the Secretary of State.
So I think she's trying to ask, what is the role of the Secretary of State in this particular bill?
The Secretary of State, the Secretary of State currently licenses, regulates, secondary scrap metal dealers, secondary metal dealers. All this does, so for copper and aluminum, this just adds the detached catalytic converters to those regulations.
So if the secondary scrap metal people are going to be accepting catalytic converters for purchase and resale, they have to register themselves with the Secretary of State in his scrap metal division. That's it.
I'm sorry.
All right, other questions? All good ones. All right, if not, for a motion? Motion is title sufficient to pass. All in favor say aye.
Aye.
Any opposed, nay. The ayes have it. Thank you, Senator Thompson. Our next bill, we have Senator McMahon here, who was kind enough to come and explain his bill, Senate Bill 2601.
Mr. Chairman, thank you. I can't take credit for this bill. This was actually brought to me by one of my constituents 2 years ago, Mary Roberts, of Lee County. She has a big heart for a lot of these young female ladies that come up missing. So basically what this is, Mr. Chairman and members of the committee, you're familiar with the Amber Alert, Silver Alerts. This would run in conjunction with that. And it's a pink alert. And really, what a pink alert is identified on lines 41 through 45. And to activate a pink alert, it'll have to be a female child that's come up missing between the ages of 13 and 17. What it does is it pretty much waives all waiting periods for missing persons. And then on lines 123, the pink alert coordinator or their designee will get the information to the Criminal Information Center, and they should prepare an announcement concerning the missing person, contact the designated media stations, request missing Department of Transportation to activate electric signs if appropriate. It's just like your Amber Alert and the Silver Alerts. It's just an opportunity to try to help cut down some of this sex trafficking and to find this. Have you take any questions?
All right, you've heard an explanation. Are there questions for the author of the bill? Senator Hickman?
I totally get the purpose of the bill, and I really appreciate the bill. But my question is, and I think we generally has made sex trafficking gendered, but males can be sex trafficked just as well as female. And so there are young children all over this country, males being sex trafficked. And I'm wondering if we can't make this bill gender neutral. Like, I think it's a good idea to eliminate time, all the time constraints when we're talking about a child who may be a victim of sex trafficking. But I think we need to expand expand our definition because, male children can be sex trafficked just as well as female children.
Senator McMahon, would you like to respond?
I appreciate your thoughts. This particular bill, the idea was to try to help young females when they come up missing. For parents, and I'm happy to entertain a suggestion, but I think the pink alert is for young ladies, and that was the intent of this particular bill. And if the senator would like to bring forward a bill or amend this one, I guess this body can decide if they would like to do that.
Senator Simmons?
I just had a question regarding, what was the rationale for setting the age between 13 and 17?
I talked with law enforcement about this, and I met with the commissioner of public safety multiple times. And we just sort of identified that age. Younger than that, an Amber Alert many times. Senator Simmons, the Amber Alert curtain would take care of younger children.
Okay. Let me ask this just for my own clarification. How does this alert differ, or maybe it doesn't, any from the Amber Alert? What does the Amber Alert cover that this one doesn't, or does?
This legislation mirrors the Amber Alert and the Silver Alert. It just sets the criteria for what the pink alert criteria is.
So you wouldn't have a single situation that would fall under both the amber and the pink? I mean, are they differentiated in some way?
That might happen. Normally, it's my understanding law enforcement doesn't activate an Amber Alert for older children.
Okay. Gotcha. All right. Other questions? If not for, I'm sorry, Senator
Mr.
Wiggins?
Chairman, may I?
Sure.
I think your question is answered on lines 29 through 30. It only applies to a child who is a suspected victim of sex trafficking. So you can have an Amber Alert when they're not sex trafficked. If they're missing, that's missing. This only applies based on line 34, victims of sex trafficking. So the law enforcement would have to make that determination based on their probable cause. I guess it could be the Amber Alert is for missing child or kidnap like that.
Right.
But this is only applying in the limited situation of sex trafficking.
Okay. Thank you for that. All right, Senator Simmons.
Yes, Mr. Chairman, but I guess to Senator Wiggins' point, but it only applies to children who are suspected of sex trafficking for a certain range. I guess that's my concern. You can be 11 or 12 in sex trafficking. But that's just all. I think it was a friendly question as to why are we saying just 13 to 17.
Yes. Senator McMahon, would you like to respond to any of these? I don't want us to just keep talking over you. Go for
No,
it.
it's fine, Mr. Chairman. I appreciate the debate. Thank you for your questions. The parameters were set after I consulted with law enforcement, sheriffs, and police chiefs, and the Commissioner of Public Safety and his staff. We met on this multiple times. These were the parameters as far as the age that was set. But, I'm willing to entertain, or the chairman would like to entertain an amendment in this body. I'm certainly open to that, as long as we can keep the spirit of the bill what it is, to help our young ladies in Mississippi who are suspected they've been sex trafficked.
We hear you.
My
All right.
family.
Senator Simmons.
So my motion, Mr. Chairman, is to remove the age requirement. The age range between 13 and 17, and it applies to anybody who's been suspected of being sex trafficked.
Any one or any female?
Anyone.
Okay. You've heard a proposed, is that an amendment proposal?
Yes, Mr. Chairman.
All right, you've heard the amendment proposal. I will refer back to the author of the bill for his response.
I appreciate it. Senator Simmons, thank you. The intent of the bill is to help young ladies that between the ages of 13 and 17. If you remove this and you open it up to anyone, you may be putting an undue burden on law enforcement. There's a waiting time when adults come up missing. Sometimes adults come up missing. So I appreciate what you're saying, but I would oppose the amendment to remove all age. And like I said, guys, Senator Simmons, respectfully, I had 4 or 5 meetings with sheriffs and law enforcement, and I had 3 different meetings with the commissioner on this, sir. And I would hope that you would appreciate that work. Thank you.
All right, we have some questions, I think, on the amendment. So Senator Hickman,
I just wanted to, I think lines 39 through 45, we just pointed out, say that what would make this different and wouldn't put an undue burden is it's specifically for someone who is believed to have been a victim of sex trafficking. So wouldn't that eliminate, like, you would have to be believed to be a victim of sex trafficking? It's just not anybody go missing. We will make this alert for specifically for sex trafficking. And I think it keeps the spirit of the bill.
Senator Simmons, would you like to respond to the question?
I agree with that, Mr. Chairman.
All right, and Senator Barnett has a question for the author of the amendment.
Yes, Senator Simmons, so basically you were saying that if there's no age in there, then we wouldn't want to be that body that missed an opportunity to perhaps save a child from being safe trafficked. Because there's multiple news stories and reports every day of young men and young women between the age of 6 or 7 years old, that we can even take into consideration the young man, the young boy, the young baby, 2 years old, that was kidnapped over in Summerall, over in Brookhaven. I forget where it was, but brought over to Summerall and raped and all of this. So I would hate for this body to make this a one gender bill when there's opportunity for young men as young as 2 years old to fall victim to this. Would you agree?
I agree, Mr. Senator Barnett.
All right, any other questions for the author of the amendment? If not, I'm going to recognize the author of the bill, Senator McMahon, to speak to it once more, and then we'll recognize Senator Simmons to close, and then we're going to vote.
I would ask each member to consider the amount of work that's gone into this, and the consultation I've received from law enforcement, and I would oppose the amendment and ask you to maintain 13 to 17-year-old. I'll just speak against the amendment.
All right, thank you, Senator. Senator Simmons, if you'd like to close on your amendment, then we'll vote.
Thank you, Mr. Chairman. I just think that sex trafficking, we all want to take it very seriously, and I don't think it should be gender specific or it should be restricted based off age. Anytime it happens in the state of Mississippi, we should be concerned about it. Thank you.
All right, you've heard the amendment. All in favor of the amendment, say aye. Aye. Any opposed, nay? The ayes, I believe, have it. The ayes have it. All right. Any other questions for the author? All right. If no other questions for a motion? Heard the motion. All in favor, say aye. Aye. Any opposed, nay? The ayes have it. We appreciate you being
Thank you, Mr. Chairman. Thank you all for your work.
Thank you, sir. Next bill is Senate Bill 2913, and we'll recognize Chairman Wiggins for the explanation of this one.
Thank you, Mr. Chairman. This truly is a simple bill, comes to us from the Chancery clerks. It deletes the language that puts them in jail if they don't report to the grand jury. So that's it.
It's a fairly arcane piece of business there. All right, any questions for the author of the bill? If not, for motion.
Title sufficient, do pass.
You've heard the motion. All in favor, say aye.
Aye.
Any opposed, nay? The ayes have it. All right, Senator Barrett, is he with us?
Yes,
Oh, yep, I'm sorry. I overlooked you. Senator Barrett, you're recognized.
thank you. This is a committee substitute, Mr. Chairman, and what my proposal does in 453326, which is the sex offender definition statute, it would require sex offenders to notify DPS if they were going to serve as a first responder, whether it be obviously in this context, it would probably be a voluntary basis. Had some issues in Southwest Mississippi wherein sex offenders were able to join voluntary firefighter units and came into contact with victims, and it's been a traumatic situation. And obviously, I think this bill is prudent and is necessary at this time.
Okay, you've heard an explanation of the bill. Any questions about the bill? If not, for motion. You've heard the motion. All in favor say aye.
Aye.
Any opposed, nay? The ayes have it. Thank you, Senator
Thank
Barrett.
you.
Appreciate it. All right, Senator Barnett, Chairman Barnett, Senate Bill 2437. I think that just got passed. You recognize Senator Barnett.
Thank you, Mr. Chairman. 2437, this bill that we passed out of corrections. And it is a bill that, I have worked closely with, Commissioner Kane on. And the idea of this bill came from the result of a pilot program that we started, legislative body started last year with, Sheriff Brian Bailey in Rankin County, where it allowed inmates who, based upon their behavior and other things with the sheriff department, to go out and seek employment, to not only seek employment, but to save a portion of their monies, use a portion of their monies to pay off fines and fees. A portion of their monies could also be used for their own personal expense. Well, after talking to Commissioner Kane, and as a result of measures that have been taken and the reduction of inmates that we now have in our population with MDOC, is that we would like to do the same thing with MDOC. And those people who are 2 years out, or 2 years or less from being released, we want to start the same pilot program over at Central lockup there, where these individuals could have the same opportunity to leave, go out and work, and 50% of their monies that they make will be in an account that they can only have access when they leave the Department of Corrections or released on parole. 25% will be used to pay fines and fees, even child support, things like this, while they're incarcerated. 10% will be for administrative fees, and 15% of their earnings can be used inside the commissary. And we're doing this because we realize that the Department of Corrections is providing a lot of job training to these individuals, and we just want them to have an opportunity prior to them being released. And another thing is that we are trying to, as effectively as we can, is to remove as many people as going to be released off of the backs of the taxpayers and get them back on the tax rolls. That's basically what we're doing. And I'll be open to any questions, Mr. Chairman, that anyone may have as it pertains to this.
Thank you. I have a question. Who sets the rate for what they make? I mean, as far as the
The
wage?
rate is what they make will be what the employers are paying them. So if the employers are paying $10 an hour, $12 an hour, that's exactly what these individuals will be paid.
So they get paid the same rate that other employees in that job criteria or
Exactly. And none of this money goes back to MDOC. None of this goes back to MDOC. The same as it is with the Rankin County pilot program that we did. And we saw it a huge success. And so we're just wanting to do the same thing with those individuals who are going to be released back to society in about 2 years or less from MDOC.
I think it's a good idea. I just want to make sure I've been here long enough to remember back when we had some prison industry type legislation, and we made a whole bunch of people in private industry mad because we were subsidizing and paying them pennies on the dollar to what other people were making. And it got really contentious because the state was essentially subsidizing inmate labor and putting private employers doing the same type of work out of business, or at a disadvantage at least.
No, sir, this is not that at all.
Great.
As a matter of fact, there has been several that has went through the program in Rankin County. When they are released, they have a job the day that they walk out with the same people that they have been working for while they was incarcerated.
Great.
And so, like I said, this is a pilot that we're wanting to do with MDOC, and hopefully we can use this. If this works fine, then for everywhere where we have a prison, whether it be Parchment or somewhere, we could do the same things and put these people back to work as soon as we possibly
And
can.
do they return home at night?
They don't
to
return
the
home, they
prison?
return back to MDOC custody at night.
So the job site has to be within certain
The
proximity
job
to.
site has to be within a certain proximity, so all of these here will be jobs that are in the Rankin County area where these individuals will be working in.
Gotcha. All right, Senator Hickman.
Thank you, Mr. Chair, and thank you, Chairman Barnett, for the work on this. I just have one question. I know you just said none of this money goes back to MDOC. Where lines 177 through 179, there's a sentence here that said wages may be subject to deductions which shall not in the aggregate exceed 80% of gross wages. What kind of deductions would it be subject to?
These are deductions, what we talk about federal deductions, that everyone pays anyway. Like if you go to work, they do know that they will be subject to federal taxes, state taxes, and those type of deductions.
So I guess my question would be, where do we get the 80% from then? I don't, federal deductions or state deductions, I don't think they're gonna get up to like 80%.
I'm not sure, Ethan, can you?
I think lines 172 and 173 exempts the work initiative from that 80%. Except as provided in section 579, which is the provision authorizing a work initiative. So they aren't subject to that 80%. They aren't subject to these deductions, was the intent.
Okay, so we're saying that they would not be,
Right. The
through
work
this
initiative is
program, we're
different.
taking that their ability to be subject to those deductions out of here.
Right. They're only subject to the percentages that are laid out on lines 109 through 119. I guess 100 through 119.
Okay. Did that answer your questions, Senator?
Yes. I need to read up a little bit, but if that's what it says, then I agree with you, and that's fine.
Okay. Senator Simmons, and quickly, we're going to have to break here in a few minutes, and if that's okay, I know there are a few other bills, so we'll ask permission of the Lieutenant Governor to come back after, but we've got about 3 more minutes. Go ahead.
Thank you, Mr. Chair. I was just trying to make sure I was clear on the difference between Section 2 and how that related to what we did in House Bill 747 last year, and Section 3, which creates the Prison Industry Enhancement Program.
What it is, Senator, is that MDOC along with MPIC, will work together. Because, MPIC also provides a job training scheme as well. And the individual that will qualify for this will be solely based upon who the commissioner thinks is worthy to participate in this program. MPIC, MPIC, will be the agency that finds these individual jobs outside of Department of Corrections. They can go and work at. So that's, we're trying to just put both of them together so that we can get the best that we can from the program that where these two have been working together. That's basically what this is.
And based on House Bill 747 from last year, the only place that we established a pilot was Rankin County, correct?
That is correct, but going forward, we have a bill out there now that says because of the success of that bill of 747, that any sheriff in any county that wants to participate can. Going forward, if this one works out, it won't be any prison, it will be all prisons in Mississippi based upon the recommendation of the individuals who qualify from the commissioner of.
And one last question. In the bill from last year, we require a report to be done so we can look at best practices, look at the strengths and the weaknesses of that pilot program. Do we have a report from Sheriff Bailey in Rankin County regarding that program?
We do. Sheriff Bailey is available for that, and I have met with him several times and others as well to view the success of that, and I've heard testimony from individuals that went through, and it has been a great opportunity for those people. Otherwise, they don't. I mean, they probably would still been where they were, but he gave them a chance. It was good, and so we're just trying to do the same thing here with MDOC.
So we can get that written report.
Yes, so I can get information from him.
All right, other questions? All right, are we ready to vote on this one? Okay, for a motion?
Time sufficient. Lisa.
Lisa. All in favor say aye. Aye. Opposed, nay. The ayes have it. We're going to entertain a motion to recess subject to call of the chair. All in favor say aye. Aye. Any opposed, nay. The ayes have it.
Good.